Hi, everyone, and welcome to Essential Learning for Renters, Understanding Your Rights and Responsibilities under the Residential Tenancy Act. And thank you so much for taking the time to watch this video. Whether you're new to being a renter or just looking for a refresher as a long-time renter, we're very glad that you're here. And since this is a recorded session, you can pause, rewind, or revisit any parts at your own pace. But before we get started, let's quickly walk you through a few helpful tips to make your viewing experience as smooth as possible. So, tips for watching the video. Adjust your audio and video quality. So use the settings gear at the bottom of the video to adjust volume, playback speed, or video quality depending on your internet connection. And then turn on closed captions for subtitles. Click the CC button at the bottom of the video to turn captions on or off. This can be very helpful if you prefer to read along or need extra clarity. And then change playback speed. You can speed up or slow down the video by selecting the settings gear and choosing playback speed. Use full screen for better viewing. So click the full screen icon in the bottom corner to make the video larger and easier to follow. And if you have any technical issues, try refreshing the page or restarting the video. It often resolves the common issue. So about the information that we will be sharing, this session includes general guidance based on the Residential Tenancy Act. So please keep in mind the information is general in nature and it means to support your understanding, but we cannot provide you legal advice. And then respectful practice reminder. So successful tenancies are built on clear communication, fairness, and respect. So as you go through this session, we encourage you to think about the principles that apply in your own rental situations. And I think with that, we can get started. So we hope that at the end of this video, you'll have a better understanding of your rights and responsibility as a renter. We also hope that you'll find the BC tenancy system less overwhelming and confusing. And in this video, we're going to walk you through the key stages of tenancy from the beginning to end and highlight what matters most for you at each step. So you will hear practical tips, learn about important rules, and get advice on how to maintain a positive relationship with your landlord. So throughout the video, we will invite you to reflect and check on your own understanding about the rental system in BC. So, all right, here we go, renters. So getting to know the BC tenancy system. So renting in BC is protected by law. This means there are rules for every step, like paying rent, living in your home, and ending a tenancy. And it's important to know that each province has its own laws. So your rights depend on where you live. And in this lesson, we will focus on how things work in British Columbia. So one of the first questions that you might have to ask is, what is RTA and RTB? And in BC, the rental system works a little bit as simple as like a team setup. So here's an easy way to understand it. We have the Residential Tenancy Act, or RTA, as our rule book. So it is the law that defines your rights and responsibility as a renter. So this law contains the set of rules for renting in BC, and it explains what landlords and tenants can and cannot do. And then we have the Residential Tenancy Branch, or the RTB, and we are acting as your referee. So the RTB makes sure that all those rules and laws and rights and responsibilities are being followed, and we help resolve disputes and provide information so that both the landlords and the tenants understand their rights and responsibilities. And then you have your renter advocates. Think of them as your coach. So these are community organization that supports the renters. They can give you free advice, help you understand your options, and give you guidance if you run into problems. So understanding the agencies and laws will help you protect your rights, know where to go for help, and get the support and guidance that you need. Now, let's clarify who the law considers as a tenant. So a tenant is someone who rents a place to live and has a permission to be there. And if you're living in the unit and paying the rent, the law will usually see you as the tenant. And then sometimes more than one person can rent the same place together. So those people, we call them co-tenants, and they are in the same tenancy agreement. It means that the co-tenants share the same rights, but they also share the same responsibilities. So everyone listed is equally responsible for things like rent and following the rules. And if something goes wrong, even if the other tenant caused the problem, you can also held responsible for it. Also, if the co-tenant decides they want to end the tenancy agreement, the tenancy ends for you as well. So we highly suggest or recommend that you have to be careful or cautious of who you are co-tenants with. The next question would be, are you covered by the law? So now that you know that you are a tenant, um, the RTA rules and protection does not or do not apply to some types of living situations. So not every rental arrangement in BC is covered by the Residential Tenancy Act. And so the RTA does not apply if you share a kitchen or a bathroom with the homeowner. Also, it doesn't apply to short term stays like Airbnbs or vacation rentals, student housing, co-ops, healthcare facilities, or business related accommodation. So if you live in a situation like this, the RTA's protection and dispute resolution options likely don't apply. That means the normal renter rights like limits on the rent increase or rules about eviction wouldn't apply either. And if you run into trouble and your living situation isn't covered by the RTA, you might want to turn to other system like the Civil Resolution Tribunal or the Small Claims Court. So now that we've confirmed that you're covered by the law, let's zoom out a bit and talk about the big picture, your rights and responsibilities as a renter. So these are the basics that apply to almost everyone under the Residential Tenancy Act. So as for your rights as a renter, you are entitled to quiet enjoyment and privacy, protection from unfair eviction, a safe and livable home, clear and stable housing rules, fair treatment under the law, and a fair process to resolve disputes and problems. But rights always comes with responsibilities. And as a renter, you are expected to have a respectful behavior, pay rent on time, use the unit legally, keep the unit reasonably clean, prevent damage, and report repairs quickly. And then act honestly and in good faith and cooperate with legal processes when it is needed. So the law is about balance and it protects the renter, but also setting clear expectations so tenancies can work for everyone. And then we will unpack each of these rights and responsibilities in more details as we go through the session. But this slide is just for your foundation and if you need something to go back to. Okay, so your tenancy is covered by the RTA and it's about to begin. Now let's discuss preparing yourself for screening. So before you sign a tenancy agreement, most landlord will ask you to go through some type of screening process. So this can feel stressful or competitive. So it's very important to know what's fair and what's not. What information can be collected during the screening. So landlords can ask for things like proof of income, references, and basic ID, and they're only allowed to use those information to decide if you're a good fit as a renter and nothing else. Under the BC Human Rights Code, landlords cannot ask questions or make decisions based on personal characteristics like age, disability, family status, or indigenous identity. And then they can do credit check. It is allowed, but only with your written consent. And just a reminder, never share your banking or credit card information because a legitimate credit check doesn't require those information. And you should also know that there are fees that landlords cannot charge. So they cannot charge an application fee, for example. And if you're successful and you choose to move in, they cannot charge you for keys or access fobs if that's the only way into your unit. So screening is very important. This is the time where you really need to pay attention to early interaction and trust your instincts. So if something feels off at the screening stage, that can be a sign of problems to come. And we also say the same things to landlords. If the person you're interacting with is disorganized or slow to respond to your questions or just generally difficult to deal with, always proceed with caution because these behaviors aren't likely to go away after the tenancy begins. Okay, so now that we're done with screening, let's talk about when a tenancy actually begins. So a tenancy is created when three things happen. First is when you and the landlord agree that you can rent the place. Second is when you're allowed to move in. For example, they gave you the keys or you have agreed to a specific date of moving in. And then third, there's an exchange of money, either through a deposit if you pay a deposit or through a rent if you pay a rent. And then once the tenancy is created, a tenancy agreement is automatically created or established as well. So that means a tenancy agreement is a contract. It's a contract between you and your landlord. And it explains the rules of renting and what both sides are responsible for. And it can come in three forms. So we have the written, the one which we all are familiar with. And then we also have verbal. So verbal meaning both of you verbally agreed or said your agreement. And then implied meaning your actions show you agreed, even if nothing was written down. So for example, when you paid for the deposit. So a written tenancy agreement is the document. It's a document of the tenancy terms and it provides both parties the clarity, the proof, and protection. So what you must know is that the RTA requires that all tenancy must have a written tenancy agreement. However, a written tenancy agreement is not a requirement or it's not necessary to begin a tenancy because as we've mentioned, a tenancy is created when there is an agreement, a permission to move in, or when there is an exchange of money. So what it means for you as a renter is that even if you don't have the written tenancy agreement, the default rules in the Residential Tenancy Act will still apply to you and you are still covered by the law. So both of you, the landlord and you, have the rights and responsibility under the RTA or the Residential Tenancy Act. So now that we know when the tenancy begins, let's talk about the written tenancy agreement and the few things to keep in mind as you sign your written tenancy agreement. So in BC, the landlord is the one responsible for preparing the written tenancy agreement. And then the RTB recommends using Form RTB1, which is the standard tenancy agreement form. It's designed to include all the required legal terms and it helps make sure that nothing important is missed. You can check them out in our website so you have an idea of what it should look like. And then once the agreement is ready, it is important that both you and the landlord sign and date the tenancy agreement because this confirms that both of you understand and agree to the terms. And after you sign, the landlord must give you a copy within 21 days. This is very important because you need your own copy to refer to if questions or issue comes up later on. And we also encourage renters to keep copies of everything. So not just your written tenancy agreement, but any conditions, any document related to your rent payment. And for added protection, you may also want to take a photo of the agreement as you sign it, just in case. And then having your own records can help prevent misunderstanding later on. Okay, let's take a closer look of what is inside a written tenancy agreement. So there are a few key sections that you should always expect to see when signing a written tenancy agreement. First, there's the basic information. So the basic information should contain who the agreement is between, the address of the unit, and when the tenancy starts. If anything here looks wrong or is missing, ask about it before you sign. And then next are the important details. So people often have question about this. So it should contain the rent and how much and when it is due. It should also contain what deposit are included and when it is due. And it also tell you if whether the pets are allowed or not. This should also be clear and easy to understand. And then finally, the agreement should say how long the tenancy lasts. So we have month to month, meaning the tenancy doesn't have an end date and it just keeps going. So a fixed term tenancy has an end date, but in most cases it will automatically become a month-to-month tenancy after that. And I should also mention that with a fixed term tenancy, a landlord might want to add um, what we know as vacate clause, so which would imply that you have to move out when the term of the agreement or the lease is up. However, vacate clause can only be included if the landlord or a close family member plans to move in, or if you're subletting the unit, meaning you're renting it off to another tenant and the other tenant plans to return. So the key takeaway here is simple. Read the agreement carefully, check for these important details, and discuss it with your landlord if there's anything that you wanted to ask. And then now that we have all those important details, let's take a look at what a tenancy agreement or what type of terms should a written tenancy agreement include. So a written tenancy agreement includes standard terms. Standard terms, these are automatic rules that comes from the law. They apply to every tenancy in BC. And even if they're not written in the agreement, for example, rules about repairs or when a landlord can enter the unit, it will apply to you and to the landlord. And then there are additional terms. So these are extra rules that you and the landlord agree on, like whether pets are allowed or if smoking is allowed. So this term should always be written down and agreed by both of you and the landlord. And they cannot also go against the law. So it's important to know that not everything in written agreement is enforceable. So some terms are illegal. These are the rules that go against the Residential Tenancy Act. For example, a damage deposit that's higher than allowed, or a rent increase above the legal unit or legal limit. And other terms may be unfair. So these are the rules that put you on a serious disadvantage without a good reason. For example, not allowing an air conditioner when there's no valid reason to restrict it. So if you see these terms, try to talk to your landlord and have them removed before you sign. But even if you do sign, illegal or unfair terms are generally not enforceable. And then finally, there are what we call material terms. So these are the most important rules in your agreement. Breaking a material term can have a serious consequence, including eviction. So for example, if the agreement clearly says no pets and you agree to that, but later on you get a pet, that could be a reason for the landlord to end your tenancy. But it's important to note that material terms is something that both you and the landlord has agreed on. That is, it is a big ticket item. Okay, so moving on, let's talk about damage deposit. So deposits are your money held for later, and they protect you and the landlord. So deposits are designed to protect you for any damages that um, may happen during or after the tenancy. So security deposit, a landlord can only ask for about 50% of 1 month's rent as a security deposit. And then pet damage deposit, if you have pets or if the unit allows for pets, the landlord can ask for a pet damage deposit. And it is also capped at 50% of 1 month's rent. And that limit applies no matter how many pets you have. And the rules for deposits are simple. So you must pay these deposits within 30 days of the landlord requesting them. This is very important because your tenancy is legally considered established once the money changes hands. So even if you sign the agreement, you don't officially have a tenancy until you've paid the required deposit or required deposit. And then you can't use the deposit towards rent without a written permission. And finally, condition inspection are essential for deposits. So without a proper inspection, it becomes much harder to prove if damage existed before you move in. So now that we've covered that, we're going to shift a little bit and let's focus on talking about condition inspection. So one of the most important steps when starting a new tenancy is the move-in condition inspection. This inspection and the written report is your protection if there's ever a disagreement about your security or pet deposit at the end of your tenancy. So a move-in inspection gives you and the landlord a chance to agree on the condition of the unit on day one. And by documenting everything upfront, you help prevent misunderstanding later and create a clear record of what damage, if any, already existed. So what are your roles? So your roles in a move-in inspection, first is to participate in the inspection. You will be given two opportunities to attend the inspection, and if you can't be there, you're allowed to send someone on your behalf. But just make sure the landlord has the name in their writing beforehand. And if the landlord doesn't schedule the inspection, put your request in writing. If they still fail to reschedule it, you're allowed to complete the inspection by yourself using Form RTB27. And then the landlord may lose the right to claim against your deposit. Next is take photos and videos. So during the inspection, look through the unit carefully, point out any damage or cleanliness issues, and take your own photos and videos for your own records. The landlord may take their own photos, but having your own set protects you in case something was missed. And the next, agree and discuss what needs to be repaired. At the end of the inspection, you will have the chance to review the landlord's note on that report. And then number four, or next, once you and the landlord agree on the condition of the unit and any repairs needed, you need to sign the report. If you later notice that something was missed, let the landlord know right away and don't wait for too long. And then lastly, get a copy of the report. So the landlord must give you a copy of the completed form RTB27 within 7 days. But we highly encourage renters to be very proactive. So if you don't receive it, request it in writing. And if the landlord fails to provide you the copy, they may lose the right to claim against your deposit. So a reminder, your participation is very important. If you don't participate in the inspection, you may also lose your right to have your deposits returned. Okay, so now that is being covered, I will pass it to Dana to discuss with you for during a tenancy.
Thanks, Shirley. Now that you've moved in and everything's going well, let's talk about some essential things you'll need to know to make sure your tenancy runs smoothly. We talk a lot about your rights as a renter, but you've also got some key responsibilities, and paying rent is number one. Landlords can issue a 10-day eviction notice even if you're only 1 day late paying or if you don't pay the full amount. It's really important to pay on time and keep proof of payment, whether that's a receipt, a check record, or an e-transfer confirmation. One key message we want to be very clear about: never withhold rent. Even if you're frustrated about repairs or other problems, stopping rent can put you at risk of eviction. Rent can only be withheld if you have an order from an RTB arbitrator or if you've been paying a rent increase that's higher than the legal limit. In that case, you can deduct overpayments from future rent, but you need to explain this to your landlord in writing before withholding rent. We also want to quickly touch on rent increases. A landlord can only raise the rent once every 12 months. They have to follow the RTB set limit, which is 2.3% in 2026, and they must give 3 full months written notice showing the amount and the date it starts. Rent increase limits are announced in the fall. So, in short, as a renter, it's your responsibility to pay rent on time, keep records, and know that there are clear rules around when and how rent can be increased. During your tenancy, you also have what's called the right to quiet enjoyment. Plainly, this means that you should be able to live in your home with reasonable privacy and peace, and your landlord can't just show up without notice, and you shouldn't be dealing with unnecessary disruptions. Quiet enjoyment also means being free from unreasonable disturbances. So normal living noise is expected, things like people walking around or everyday sounds from upstairs, but ongoing issues like excessive noise or secondhand smoke or harassment or pest problems might get in the way of your right to quiet enjoyment. You also have the right to use your home normally. That includes inviting guests, cooking foods you like, practicing your religion, and using shared facilities as long as you're following your tenancy agreement. This is both a right and a responsibility. So, just as you're entitled to enjoy your home, you're also expected to make sure your guests and your pets don't interfere with other people's ability to enjoy theirs. If you or your guests or your pets are regularly disturbing others, that could lead to eviction. So, this is a right and a responsibility. It protects you and it also requires you to be a good neighbor. So, yes, you're entitled to quiet enjoyment, but let's talk about when a landlord can legally enter your home. Landlords have to give you written notice before coming in. That means at least 24 hours notice with the date, a time between 8 a.m. and 9 p.m., and the reason they're coming in. Common reasons might include to do some repairs or just to do a scheduled inspection. There are only two exceptions where a landlord can enter without notice. So that's real emergencies like a fire or a flood, or when there's a court or an RTB order. And just like you have the right to privacy, you also have a responsibility to allow access when a landlord gives proper notice. So the balance is simple. You get privacy and peace, and your landlord gets reasonable access to maintain their rental unit. Now that we've talked about access, let's look at who's responsible for what when it comes to repairs and maintenance. As a renter, your responsibilities are mostly about basic care. That includes keeping the place reasonably clean, taking care of garbage and recycling, replacing things like light bulbs, and fixing any damage caused by you, your guests, or your pets. You also need to report repair issues as soon as you notice them, and it's best to do that in writing. Once you've reported a problem, your landlord's entitled to a reasonable amount of time to fix it. Landlords are also responsible for the big essential things like heat, hot water, electricity, locks, and the structure of the building. They're also responsible for repairing appliances if those appliances are listed in your tenancy agreement, and for handling any emergency repairs. They'll likely want to come in on a semi-regular basis and check the smoke detectors, but this is also something you should be checking. So again, it's about balance. As a renter, you take care of day-to-day upkeep, and the landlord takes care of major repairs that keep the home safe and livable. Emergency repairs work a little differently from regular repairs, simply because you can't wait weeks for them to be fixed. Emergency repair is something urgent, something that affects your health or safety, or something like a serious leak, a broken heating system in winter, or unsafe electrical issues, or a damaged lock that affects your ability to secure the house. Your landlord is responsible for making these repairs, and hopefully they will as soon as they're told about them. But keep in mind, just because a broken appliance is extremely inconvenient for you, it does not make it an emergency repair. If a landlord doesn't respond to your request for an emergency repair, there's a process you need to follow. First, try contacting your landlord twice using both phone and email or text. Keep records of everything, photos, videos, messages. If your landlord doesn't respond, you can arrange this emergency repair yourself, pay for it, and then apply to the RTB to have that amount deducted from your rent. Just make sure you keep your receipts and all of your documentation. All right. So let's look at some common scenarios. These are things that we notice that come up often during a tenancy. We'll start with guests that we hear a lot about guests. Your landlord can't unreasonably restrict you from having guests, but it's up to you to make sure that your guests don't become occupants. If a guest gets their mail at your house, pays for any of your rent or utilities, stays overnight regularly, moves in personal items or their pets or their furniture, or has a key to the unit, it would be reasonable for your landlord to assume that they have begun living there. Reasonable guest limits include enforcing noise restrictions and making sure your rental doesn't become overcrowded. Unreasonable requests are things like guest fees, restrictions on the number of guest stays per year, or guest check-in policies. But what if you want someone to move in? Look at your tenancy agreement. Sometimes there's a clause in there that allows for additional occupants, but it may include a term that the rent goes up by a specific amount if the number of tenants goes up. If there's no clause, a landlord can't increase the rent because someone moves in. Also know that this increase is based on an additional adult occupant, and it's not considered a rent increase under the RTA. So the landlord wouldn't have to give 3 months notice, for example. And even if there is a clause in the agreement that says rent goes up if someone moves in, the landlord can't increase the rent if the additional occupant is a minor or someone under the age of 19. Moving on from guests, let's talk about some other common concerns that come up during a tenancy. And we'll start with pets. If you have a pet, you're responsible for any damage caused by it, and that includes costs above and beyond the pet deposit if the damage is significant. And just a reminder, even if your pet dies or no longer lives with you, the pet deposit isn't typically returned until the end of the tenancy. Guide and service dogs are treated differently. They don't require a pet deposit, and landlords can't apply pet restrictions to them. For smoking and cannabis, always check your tenancy agreements. Some buildings are completely non-smoking, and you're expected to follow those rules. While it's legal to grow non-medical cannabis in BC, landlords can and often do include restrictions. The tenancy agreement should clearly state whether you're allowed to smoke and where, and whether or not you're allowed to grow cannabis. Okay, so you've had a good run and the tenancy is now coming to an end. But just like when any relationship ends, it's always best when there's no hard feelings. In this next section, I'm going to walk you through what to expect at the end of your tenancy. We get a lot of questions from renters who want to move out before their lease is up, which is tricky because you signed a legal document saying you plan to stay for a specific amount of time. If you're on a fixed term lease, it can't end early unless both you and your landlord agree. There's a special circumstance like you're fleeing family violence or you've been assessed as needing to move to a healthcare facility, or if the RTB orders it. Otherwise, you're responsible for the rent until the end of the lease or until the landlord can find someone else to rent the place. If the landlord has to lower the rent in order to attract a new tenant, you could be responsible for paying the difference. This is another reason you need to be really thoughtful when you sign a fixed term lease. For a month-to-month tenancy, you just need to give proper written notice, and that notice has to include your name, the date, the address of the unit, the date you plan to move out, and your signature. And remember, you need to give this notice to your landlord at least 1 full month before your rent is due. Ending a tenancy properly protects your deposit and helps you avoid penalties, so getting that written notice right is important. Now that we've talked about how tenants can end a tenancy, let's look at the other side when the landlord wants to end the tenancy. Any eviction notice has to be in writing. It has to use an RTB approved form, and it has to clearly state both the reason and the effective date. The two most common types of notices are first, the non-payment of rent or utilities, which would come up as a 10-day notice. So you have 5 days to either pay the full amount or dispute the notice. And if you don't, the eviction goes ahead. The second most type of notice is eviction for cause. And this is a 1-month notice for things like serious damage, illegal activity, repeated late rent payments, disturbing other tenants, or breaching a material term of the tenancy agreement. So you have 10 days to dispute this type of notice. The key thing I want you to remember is that every valid notice has timelines, and those timelines matter. If you receive a notice, act fast so you don't lose your right to dispute it. Okay, so we've talked about evictions for non-payment of rent and evictions for cause, the 10-day and 1-month notices. Now let's look at other reasons a landlord might want to end a tenancy. The first is landlord's use of property. That's when the landlord, one of their immediate family members, or sometimes a purchaser of the property, wants to move into it. For this one, you get a 3-month notice and you have 21 days to dispute it if you think it is invalid. So if you think that the landlord is not planning to move in, and importantly, the landlord has to give you 1 month's rent as compensation. The second is for major renovations, demolition, or conversion. For these situations, the landlord has to give you a 4-month notice and you have 30 days to dispute it. They also need to have all the necessary permits and approvals required by law, and they have to have plans to demolish the unit, convert it into strata lots, or convert the property into co-op housing, or convert it into non-residential space like a commercial space. After the renovations, you would have first right of refusal, meaning you get the first chance to move back in if you want to. Now that we've talked about the different types of notices a landlord can serve, let's look at one more way a tenancy can end, and this one is much simpler. It's by mutual agreement. A mutual agreement to end tenancy just means that you and your landlord both agree in writing that the tenancy will end on a certain date. There's no dispute process, no formal notice period, and it's simply an agreement between you and your landlord. You'll use Form RTB 8, and it's really important that both of you sign it and that you keep a copy for your records. One thing to keep in mind, if you end the tenancy by mutual agreement, you won't receive the compensation you might have been entitled to if the landlord had served you a formal notice to end tenancy. On the other hand, landlords also can't claim compensation from you that they might have been entitled to if you'd ended a fixed term lease early. A mutual agreement is the cleanest, simplest way to end a tenancy. Just make sure it's in writing, that it's signed, and that everyone keeps a copy. Now we're going to shift to talking about how to get your security deposit back. Okay, we can't talk about security deposits without mentioning the move-out inspection. The move-out inspection works just like the move-in inspection. It's your chance to walk through the unit with your landlord and compare the condition of the home when you first arrived to the condition that it's in now. This is a key document that determines whether your security or pet deposit gets returned. If your landlord doesn't show up for the inspection, they could lose the right to claim any of your deposit. And if you don't participate, you may lose the right to get it back. Before the inspection, make sure the place is cleaned thoroughly and that you've repaired any damage that you caused that's beyond normal wear and tear. Otherwise, you can be charged for cleaning or repairs. And just like at move-in, take photos or videos so that you can have your own record. The inspection has to happen on or after the last day of your tenancy, and your landlord must offer you 2 opportunities to attend. All right, we're nearly done, but we left deposits for last. I would bet that our information services team, the folks who answer the phones at our call center and the people who answer your emails would agree that people are most often concerned and confused about damaged deposits and how to get them back. So let's talk about how to get your security and pet deposits returned at the end of your tenancy. The main thing to know is this. Your landlord can only keep money from your deposits in very limited situations. They can deduct money for they can't deduct money for unpaid rent, damage beyond normal wear and tear, or unpaid utilities, but only if they're listed in your agreement. To start the process of getting your deposit back, you need to give your landlord your forwarding address in writing. Once they have that, they have 15 days to either return your deposit or apply to the RTB for permission to keep some or all of it. A landlord can only keep money from your deposit if you agree in writing or if they get an RTB order. Otherwise, the deposit has to be returned. One last detail that's easy to miss. Interest is calculated on the full deposit first before any deductions are made. So give your landlord your forwarding address, watch the 15-day timeline, and know exactly when a landlord can and can't keep your money. All right, thanks so much for watching this video. If you've got additional questions, please reach out to us by visiting our website at gov.bc.ca/landlord-tenant or by calling our call center at the numbers listed on the screen or sending us an email at hsrto@gov.bc.ca. As well, we offer regular real-time webinars, so consider joining us. And at these sessions, you'll have an opportunity to ask for any of your questions of our information services team. And you can register on our website.